And I know a lot of you have traveled a long way too. Thank you, Mayor Ward, for hosting us in Braselton. Senator Ginn, thanks for hosting us in your district, and look forward to a good discussion today. This is supposed to be our final study committee meeting, and so we hope to, after hearing from the speakers, have some good discussion. And being this is Senator Ginn's district, he's going to welcome the speakers here and move us on down the agenda. So thank you.
Thank you, Chairman Hood. I want to thank everybody for turning out today. And really, I know we've already thanked the mayor, but where's Jennifer? Where's Jennifer Scott? Jennifer, stand up and take a bow. Said let's congratulate Jennifer Scott. Is the longest serving city manager that I know anything about. Said she's been here for about a quarter century or somewhere close. Said as the city, and I'm going to pick on Mayor Pat Graham, who's the chairman of the Barrow County Board of Commissioners, who served as mayor for 2 terms here as the mayor of Braselton. So when we talk about the things that are going on in Braselton, Georgia, said it used to be a little cotton town that Kim Basinger bought, and it's really impressive what all's going on. So for me, Mayor, thank you very much for hosting this. Your facilities are magnificent. And if anybody in here needs access to Wi-Fi, just so you know, there's a barcode or QR code right outside the door that you can get on their Wi-Fi. And if you need the restroom, it's down at the end of the hall, on the right outside. My name is Frank Ginn, and me and Chairman LaHood have worked with our committee members, and I want to thank all our committee members for being here today. This is the third meeting of the service delivery strategy meeting that we're working on. We'd like it to be our final, and if you see, there's an agenda here. We're gonna go a few things differently on the agenda. I'm going to change things up like they do in baseball. So for me, I had a request, and I want to start off with I'm going to pick on Angie Davis and Pat Graham, and I'm not sure how y'all want to work it. If you want to tag team it, or if one wants to go before the other, but because I think at all our committee meetings we've heard about the friction between two of my favorite local governments, and that's Bexar County and the city of Winder. And it's where I wanted to put a face and a name to those communities, because you're going to find out, hey, these are executive officers of their local government that are working really hard for their people. And for me, I congratulate both of them. I know I've been harangued before for saying things that sometimes I just said, well, it needed to be said. I'm going to brag on you, because for me, they've stayed at the table. They've worked through a lot of issues, and there's issues that many people know, and a lot of folks that don't. But Chairman Graham, I'm not sure how you want to start the presentation. If you want to start and introduce your council, but I'd love to have y'all start off our meeting.
Thank you, Senator. Let's see. Can people hear me? This is a little high. Is there a way to?
Keenan's got you.
Is it working? Yes. Excellent. Thank you. I'd like to thank the committee for allowing me to speak today. I'd like to thank the co-chairs, Senator Ginn and Representative LaHood. I appreciate your time and diligence on this important effort, and also thank the Mayor of Braselton for hosting. I almost could have walked here today, so it made it very convenient for me. I did serve 2 terms as the Mayor of Braselton. Between 2002 and 2009, we renegotiated 6 different service delivery agreements. We did it twice in Hall County, twice in Jackson County, once in Barrow, and once in Gwinnett. That involved working with 36 different cities, and it's a process that requires communication, cooperation, and a lot of give and take. In 2009, Gwinnett County had an impasse that led to a court challenge, And what finally tipped the scales in Gwinnett County was bringing new leadership that was eager to resolve the conflict. Chairman Bannister had refused to negotiate with the cities in Gwinnett. When Chairman Charlotte Nash was elected, she worked to resolve the tax equity issues which involved the cost of the planning department and the cost of the Gwinnett County Police Department. Sometimes the roadblocks to achieving a service delivery agreement come down to a people problem. That's when we have to rely on our voters to correct people problems. And they do so by putting new leadership in place. Much of the discussion of this joint study committee has focused on the Winder-Barrow service delivery dispute. Our service delivery agreement should have been adopted in 2018. That's 5 years ago. All of you are aware the Georgia Supreme Court heard oral arguments last month. Another big item has happened. We've had municipal elections. Let me introduce at this time the mayor-elect of the city of Winder. He's not going to have a chance to speak today, but he's someone I'm going to be speaking with a lot in the coming weeks, months, and years. Jimmy Terrell. I'm confident that new leadership in Winder will come to the table in good faith and work with us to adopt a service delivery agreement. The county and the other 5 cities have already been ready to approve an agreement since 2018. And it's possible we may come to an agreement before the Supreme Court has a chance to rule. I've had a chance to review the 11 recommendations, kind of procedural recommendations that are before this committee today. And I took a very high-level look at them as a local elected official, and I looked to see which of those items might have helped Barrow County and Winder come to an agreement, and which ones would have made no difference. I do think all procedurally, the majority of them are good things to put in place. But I want to bring up one item that was not on your list that would have definitely made a difference in our ability to adopt a service delivery agreement. The current service delivery statute allows the county seat a veto of the adoption of a service delivery agreement. In our case, the county seat represents about 22% of the population in our county, and they've blocked the other 6 local governments from adopting an agreement for the last 5 years. We met with all of our cities after each round of court rulings to make sure that we were all still on the same page. We were. The local governments representing about 78% of the population in our county have been held up by a city that represents 22%. I think there might be a problem with the legislation when a veto objection cannot be overridden. All the other local governments representing 78% of our population should have had an opportunity to say, wait a minute, this agreement will work for us. I've reviewed the 11 recommendations, and I looked objectively through would they have made a difference, would they have helped us resolve our conflict. Took a very high-level look. Angie, our attorney, is going to come to you with all the details. Mine are minimal. Of all the agreements, I think 9 of them would have had no impact at all. They would have helped, but I think we still would have had this impasse that's lasted for the last 5 years. The one item that is the largest motivator of all of these that are listed here is number 8. There has to be some kind of consequence for not coming to the table and not negotiating in good faith. And number 8 mentions the loss of QLG status. That is a motivator. Number 8 says that the longest a QLG status can be held in abeyance, or that the sanctions can be held in abeyance, is 6 months. That would definitely help. I've had some discussions with other city and county people over the last several days since I saw the list. And actually there are some that feel there should be maybe even a larger motivator. One of the discussions I had with a senator that's not on this committee is perhaps withholding local option sales tax or 50% of the local option sales tax proceeds to local governments that have an impasse that lasts longer than 6 months. If you put a little bit of financial pain into the situation, it has a tendency to bring people to the table quicker with an eagerness to work out the issues. Other items on the list, just I wanted to briefly mention item number 2. I think that item might need some clarity. It's trying to get the DCA to tie the timing together between service delivery and comprehensive planning. And the last sentence, or next to the last sentence, I have a question about the SDS negotiation cycles with comprehensive planning cycles for each county in the affected cities to include comprehensive planning involving local option sales tax. And I'm not sure if you're trying to tie the negotiation of local option sales tax to all 3 of those things or not. So I would like to see some clarification on that. Or maybe a service delivery agreement needs to have an additional agreement that says how the jurisdictions are going to approach negotiating their next local option sales tax. But I think item number 2 could use a little bit of clarity. And one of the items that also I hope this committee will look at is item number 10. The beginning of item number 10, wanting appropriate and accurate geographic maps to detail service areas, I think that's right on. I think that's procedurally something that is a benefit. I have a concern about the second half of item number 10, where if a jurisdiction that has a service area is reluctant or unable to serve, another jurisdiction can come in and serve. That one seems to throw the supplemental powers clause right out the window. Unfortunately, I know there are some local governments that might try to use utility service to thwart personal property rights. They may try to deny utility service to stop a development from moving forward. Forced annexation is another issue that comes into play there. Forced annexation should not be necessary simply to receive a basic utility service or to deny utility service to stop development. All of those things are unacceptable. But I do think, from a legislative standpoint, I'm hoping this committee will continue to honor home rule and allow local government officials to do what local governmental officials do. And I'd be happy to answer any questions, if anyone has any, about this or any other topic. Thank you.
Are there any questions from the committee?
Yes, sir. You're going to have to go a little bit louder for me.
Is that better?
Yeah, it's much better.
Just a little clarification on the objection you have to another government providing, say, water and sewer utilities when the one that has it in their service area is unable to provide it. I've been in situations where, if it's in the same county and, say, the county government or the city cannot get it there without great expense, but right around the corner in another service delivery area, that city or that county government can get it to them.
Yes, I absolutely agree with that.
Okay.
And I think that's item number 9, that there can be swaps of service area and swaps of territories without reopening the entire service delivery agreement and bringing every entity back to the table.
Correct,
That
I
agreeing
agree.
partners can swap. One of the challenges I've seen over the years with the multiple service delivery agreements that I've been involved with, sometimes there are areas in rural parts of the state where utilities are not present. We actually had a situation in South Hall County where there were some utilities, particularly sewer service, that was not available at the time we did those agreements. The DCA at that point in time would not accept a map that didn't have the entire geographic area of the county assigned to a service provider. So we actually did have jurisdictions that couldn't provide there, but we were not allowed to put a gap in the map showing no service provider. The entire map had to be divvied out to service providers. One of the creative things that Hall County did years ago was put together partnership areas where there were areas that no utility was close by. They put together a partnership area with a narrative that allowed different utilities to come in and partner or work independently to provide a service in an area that did not have a specifically defined service provider. So there are creative ways with the current statute that local utilities can do that.
And you're talking about within a county and its local municipal governments?
Yes.
Okay.
Thank you very much.
Are you going to introduce the next
Well,
speaker?
I am, said that, or you can if you'd like to. And one of the things I want to make sure everybody understands, if y'all saw some of the emails back and forth, with what we sent out the end of last week, me and Chairman LaHood had talked to some of our partners, and we came up with a kind of a starting foundation point for our discussions on where we might go for committee recommendations. Those are just discussion points, and it's one of the things that, I thought, okay, if we're going to try to do this as a final meeting, we're going to need to spend a couple hours here just with our committee members just to talk about where we want to go. But I thought I'd throw some ideas on a piece of paper that we could share with the committee members. And I'm glad to have anybody in the audience that wants to address that as we move forward on our speakers today, because it is one of the things that, you got to start with a blank sheet of paper and move forward. Well, I put a few dots on the paper to begin with. So I hope everybody will keep that in mind as we move forward. And next, I'm going to call on my friend, Miss Angie Davis, said and I think I've known Angie. She was actually a county attorney back when I was a county manager a long time ago. And I know she does a great job of representing all of her clients, but she's here representing Barrow County, and she's been involved with the litigation on this all the way up to the state Supreme Court, which is more recent. They haven't ruled on it. So, Ms. Davis, one of the things I do want to make sure that our committee understands, I didn't put anything in there about the Supreme Court case, and what was going on with it. And the reason being is because I think that might be getting us into a little ahead of the cart. So if I'll let you give some comments. There may be some questions. So thank you, Ms. Davis.
Yes, sir. Thank you, Senator Ginn, Representative LaHood, members of the committee. Very much appreciate the opportunity to be here. As Frank said, I'm Angela Davis, and while I am proud to represent Chairman Graham and Barrow County, and I have handled the litigation before the Supreme Court, I also have a unique perspective on these matters because our firm represents numerous cities and counties, as well as development, building, airport, and water and sewer authorities all across the state, more than 100 different legal entities in just this year alone. So I'm hopeful that based upon that, as well as the fact countless SDS negotiations from South Georgia to North Georgia and all places in between, that we have seen a lot in this area. Also, we train and teach quite a lot on both sides of the aisles for cities and counties and local government issues. So I'm hopeful that based upon all of this, that I can be a useful resource to this committee and offer you some insight as you grapple with what's very difficult issues, because I do believe we've seen and heard just about everything in the local government SDS arena. In extending this invitation to speak, Senator Ginn did indeed request that we not address or seek to re-argue the litigation that's pending before the Supreme Court, and I could not agree more. This matter was argued, as you've heard, last month before the Supreme Court and remains pending. This case is a culmination of years of litigation that goes from the trial court ruling for the county on all of the issues in the county's favor to a Court of Appeals decision that upheld that decision for the county, and then to the pending appeal in the Supreme Court. And the Supreme Court appeal itself has involved the filing of briefs by not only Barrow and Winder, but also 2 cities on behalf of the city of Winder and 13 other counties in support of Barrow, as well as, of course, filings by ACCG and GMA. So we are thankful that out of respect for the time and investment of all these parties over all these years, that the will of the co-chairs is that those issues be left in the discretion of the Supreme Court and not be a part of what this committee is doing here in this session for the legislature. And I will confine my comments as requested, and again, we appreciate that because I think that's the respectful way to proceed. In a communication I received yesterday, Chairman Corbett mentioned and urged the committee to address several substantive issues. Indeed, some of those very issues are pending before the Supreme Court. So we respectfully oppose that suggestion to address those issues before this legislative committee. And I cannot and I will not respond to each of those out of respect for Senator Ginn's direction. But if the committee does endeavor to address those substantive issues and go into those issues that are pending before the court, we are hopeful that you would allow additional time for interested parties to comment on those substantive issues because we are concerned about some of those recommendations. We believe they'll be addressed directly by the Supreme Court. Some of them are addressed directly by the drafters of the SDS Act itself in their legislative committee report known as Charting the Course, and or they're unconstitutional as proposed. So if there's going to be any delving into those subject matters, irrespective of the direction, we would ask for additional time because the schedule of having a completed report by the end of the month, we believe, would just be too hasty if getting into all of those substantive matters. So again, I will confine my comments and focus on the procedures and particularly focus on the 11-point overview that was provided by the co-chairs, which we appreciate very much to have some substance and some framework for our discussion. But going just first off that framework, I would like to offer a key recommendation similar to what the chairman mentioned with respect to suggestion that we have that we believe would be a procedural tweak that could have a very significant impact on negotiations around the state. In my experience, and I've had 2 of these cases now go to the Supreme Court, the most contentious, prolonged, and expensive negotiations have been involved where there's been driven by one city opposed not only to the county, but opposed to all the other cities in the community. And this is possible because under OCGA 367025B, the statute sets up what is an effective veto power for certain cities based upon how the statute defines the parties that are necessary to sign the SDS agreement. So we believe paying attention to that portion of the statute alone to remove the ability of one city to have an effective veto power would be the most effective modification that could improve the SDS Act. This one very modest procedural revision would enhance the ability of all governments in a jurisdiction to be heard, to reach agreement, and ensure that other cities are not disenfranchised. While this concept would need to be fully vetted, and I trust the discretion of this committee to do that, we have made some suggestions in the materials that I had placed at your seats today. The black language, this is at page 4 of the materials that you have from my office. The black language is the current statute that provides in subparagraph B who the necessary parties for signature are. And then in red, we offer 2 options. Again, these are suggestions for a starting point on this conversation. Option 1 would provide that if there is a holdout city, that the other remaining parties, if they all agree to the SDS strategy agreement, that they could proceed without that holdout city, and the holdout city then would be subject to sanctions until they decided to agree to the strategy. Another option would be to set some kind of population threshold based on municipal population. So if there's a holdout city, if there's an override by, say, a supermajority, maybe 65%. I left that percentage number blank for consideration and debate. But maybe it's 65%, maybe it's 75% of the municipal population. If that much of the municipal population is represented by cities who are in agreement with the SDS agreement that the county and everyone else agrees to, except for one holdout city, then again, the parties could proceed. So again, it's just some options we would ask respectfully for you to consider. Because again, the cases that I've seen and the 2 that went to the Supreme Court, both of them involved one city that was in disagreement with the other cities in the county as well as the county. And if there was some mechanism to get around that veto, then those cases wouldn't have gone forward to that point and to that extent. So we believe that could be incredibly effective. And it would also, I think, benefit counties and cities alike. With that as our key recommendation, I'd also like to talk through some of our primary objections real quickly with the framework of the 11-point overview. As Chairman Graham said, I think generally what's in the 11-point overview is favorable, and many of the things that are discussed there could be a real benefit to this process. But there are a few things that we'd like to point out that we may not necessarily be covered in the overview, but we want to ensure that this committee doesn't branch off into those subject matters as I'm going to mention. First, we would oppose any kind of binding arbitration or even mandatory arbitration. So at one point, there was some conceptual discussions about a binding arbitration process. And I think the whole goal here is, how do we ensure that communities will come to the table and negotiate in good faith and be motivated to get a deal done? And some think penalties, some think, forced arbitration, and there's a variety of ways maybe to get at that better negotiation process. But a forced arbitration or a mandatory binding arbitration, in our opinion, would be unconstitutional. It would take away the home rule powers of the local governments to make these service delivery decisions themselves and would be given it to an arbitrator. That has been stricken in other cases as unconstitutional, and we believe it would be subject to court challenge as well. And if we went with a binding arbitration provision, we would just see ourselves in different litigation about a different topic. So we don't think that would be useful or helpful. We also think mandatory arbitration would likewise be undesirable. And here's the reason. I have heard many people say that the goal of this committee and the goal of the interested parties is to ensure that this process is less expensive and preserves the relationships in the community, because we see expensive, time-consuming, prolonged, and then everybody in the community ends up hating each other by the time these are over. So if those are our goals, we don't believe that mandatory arbitration is something that should be included here, because mediation is an opportunity to come together in a collaborative, creative way to exchange ideas and make decisions. Arbitration is nothing short of a full-blown trial, and even some of the drafts that we've seen, it's an opportunity where there's an exchange of evidence, there's documentary evidence presented, there's testimony by parties. So the mayor is going to be on the stand, the county's council is going to cross-examine them. I promise you that's not going to do much to preserve relationships, and it's going to be just as expensive as going to court. And so we believe forcing parties to arbitrate would be a mistake if your goals are lessening expenses and in preserving relationships. Instead, we think that could be an option. There's some communities that may know, hey, we need a little bit more, and they may choose to do that. That's fine. But I think otherwise it should be a choice between mediation or arbitration. Our second major objection would be with the involvement of DCA. With no disrespect at all to DCA, DCA has so many responsibilities and they cover so many vital local government functions. But the land dispute resolution process that requires DCA to maintain a list of arbitrators and to manage the strike selection process for seating an arbitration panel, it's just not worked very well for anybody that's been involved, and I've been involved with that for years. It doesn't work well in a lot of respects, not to the fault of DCA, but because maybe we can't get qualified arbitrators who'll sign up. Part of the reason for that is the fees are so small, people can't take a day off work, are not willing to commit the time and energy to be trained and to understand the issues and to come and spend a day. And there's also been instances where DCA has not been flexible in ensuring the panel got seated if one of the parties did not follow the rules. And so I think creating a process where DCA is the driver in terms of creating a panel of approved arbitrators and mediators would be a mistake. The notion of dispute resolution process has been part of law and litigation, for decades, if not centuries. Typically, the parties will choose a mediator of their own or an arbitrator on their own, and they set the parameters for how they'll proceed. This process should be no different. The parties are best suited to retain a mediator, an arbitrator, who is experienced in the necessary field. If it's about roads, then you might want to have someone who has a particular expertise in roads. If it's heavily financial based, then you might want someone with that kind of expertise. But the parties can decide those issues for themselves, and we believe that would be best suited for them to do that. And then in doing so, the parties are buying into who they selected. In the arbitration process, in the annexation context, you have a strike option, but you're otherwise forced into whomever is selected by DCA. And we would urge this committee not to go that route with any proposed revisions to the statute. Currently, the parties select who they wish to mediate, and I think that's the best way to continue. If you do go with some kind of approved panel, we don't believe that current or former elected officials or staff are necessarily the best people to put on those panels, for a few reasons. For one, as you probably figured out by now, the legal issues are incredibly complex and complicated, And parties could benefit from a lawyer, or I've used a former judge in several of my mediations that has been very effective. Those folks are out there. Senior judges are out there and can be utilized. Retired folks, retired attorneys, or attorneys that have served as county or city attorneys throughout the state. They can bring a lot of information and a lot of expertise to bear. But when we depend on, like in the annexation context, it all being former city and county officials or staff members, then you're necessarily bringing people in who are going to come with a bias for how they have done things. Not necessarily a negative bias for one party or the other, but just the way they've done it. You know, this is the way we do it in our community. It works fine for us. It ought to work fine for you. But the whole thing about constitutional home rule and the whole thing about the SDS Act is the reference to flexible framework. It's supposed to be a decision made by the local officials who know their community best, and a flexible framework where they can work together to come out with the best service results possible. And bringing people in who may say, well, we do it this way in my town, and that worked fine for us, so you ought to do it that way too. We believe that would unartificially result in some biases and perhaps not have the neutral impact that would have if we had a lawyer or a judge or a consultant or someone that's not, that has a more broad brush of potentially of experience. The last thing I want to note as a major objection with what's in the current 11-point plan is something that the chairman mentioned too, and that is item 10 with respect to the utility service issues. So I agree wholeheartedly that requiring maps would be very useful. And in fact, DCA has kicked back SDS agreements for years now if there's not a map attached. But I think putting that in the statute would be good. And I think having that map be specific as to parcel would be very helpful, because sometimes we've had the best of intentions with maps, but there's a line drawn down the middle of a parcel, and then you have to figure that out. So parcel-based mapping for territory would be, I think, very useful. And that's a great procedural suggestion. But then the automatic trigger concept of what happens if a party cannot provide the service, we believe that goes beyond procedure, and that gets into making substantive decisions in this legislation, which we believe that the committee was to be avoiding in this round of consideration. If the automatic trigger is there, so as it's written now, it says if one party can't provide, then another party who can take that territory. If there's any kind of automatic trigger, again, we would oppose it because that's a substantive issue. That's getting into the service decision. But for other reasons, we believe that that could be a very dangerous result. We believe it could be like a gotcha grab a territory for any opportunistic county or city who might wish to enhance their territory areas. It would create sort of a free-for-all Wild West approach that could have a compounding effect as eager governments gobble up territory outside of an agreed-upon service boundary. Remember, these maps have been agreed upon in a contract. So to have any kind of statutory method that says, okay, automatically forget your agreement, another party can do anything they want, I think that's incredibly dangerous, not only from a legal perspective as breaching the contract, but also in terms of the results that would occur. And to try to answer even fuller Chairman Corbett's question about, what would the harm be? For one, the way the statute provision would have to be worded would be very difficult, because as it said now, what party does not have the capability? Well, that's very vague. What does that mean? What does capability mean? What does be able to provide mean? When do they mean? Does it mean it has to provide it today, or does it mean provided in 6 months when the customer needs the service? I think that could be abused in a lot of ways in terms of saying, oh, you can't do it right now? Okay, then we're going to take your territory and run. And that's not consistent with the agreement. I agree with the chairman that I think it has the potential to undermine the Supplemental Powers Clause, which is built upon serving within your own jurisdiction or having an agreement if you allow someone else to serve. That should be the same thing here. We would urge this committee to not touch this at all. If you want aspirational language about communities working together, that's fine. But this is not an issue that needs fixing. Responsible governments do this every day. As the chairman mentioned, there's land swaps. Okay, you can't provide that. or your line won't be there for 6 months. They work with the customers. They determine when the service needs to come online. And many times that provider may not be able to provide the service that day that they've been asked by a customer, but that customer may not need that service for a year. So they give them a certification letter and they have that line expanded or extended, and then they're ready to provide the service. But under this kind of a potential automatic trigger, that kind of thing could be unwound and unravel and not be permitted. So again, in terms of a flexible framework, which the statute requires. Okay.
Let me ask you a question.
Sure.
I agree with what you're saying there, because there does need to be some negotiation between the counties and the cities. For example, in one county, I know they say if you cannot provide the service, you have to give a letter to the person. If you can't give within 1 year or 2 years, then they have the ability to take it. And so for that reason, I agree with you. There's not enough detail in here to say you can just take that position. The question would be this: should this maybe add a comment that a service delivery agreement should provide a direction for when a government cannot or will not provide that? Should that maybe be part of this legislation to include that they will cover that in their service delivery, so it's not left in an open end?
Yes, and I understand your question, and I think that's a really fair question. And I think, as the chairman mentioned, left alone with this flexible framework, which the SDS Act has purported to be, and I think is, Hall County came up with a very creative solution just like that. They provided for how they would have these partnership areas of their territory, and they provided that in their SDS agreement. So I think absolutely governments could do that, but over the course of 10 years, things change, and so that's a challenge as well. I think it's much better not to try to legislate this. This is the kind of cooperation that needs to happen and does happen already organically. So I think it would be better in the legislation not to touch it. If you want to offer some aspirational language that the party should consider what would occur if, in fact, service could not be provided, but I don't think it should be a mandate, and most importantly, I don't think it should be an automatic trigger. I think it has to be based on agreement of the parties, that the parties can agree, because in SDS, there's so many services. I mean, I think like in the Barrow County Winder, there's probably, 58 services or so? I mean, a lot of services that we're talking about. And you can't just carve one out and say, okay, we're going to now say, oh, whoops, you're out of your territory, and then unwind that, because that could have been a part of the negotiation for some of the other 48 services. So I think you have to leave it to the agreement of the parties. And I see Senator Ginn tapping his watch, so I will stop with that. You have some comments in the materials I gave you as to each of the individual 11-point items. I apologize if I overstayed my welcome, but I thank you for the opportunity and happy to answer questions now or later as your time allows. Thank you.
Thank you very much, Ms. Davis. One of the things that, for me, this is like going down a list of friends here. Said, hey, the next speaker I'd like to call on is my friend David Maynard, who's the mayor of the city of Winder. The Mayor Maynard, if you would come forward, and if you want to bring your council with you, or however you want to tag team it, I'll let y'all do the same as Chairman Graham and council, or however y'all want to make that work.
I guess I'll come by myself. May I pass something out to you?
Please. Just hand it to me. I'll pass it out for you.
Honorable members of the committee, I appreciate the chance to talk to you. I'm David Maynard. Been the mayor of Winder closing in on 12 years, and before that I was on the council for 4 years. But I've lived in Winder all my life, and I love the town, I love my county, and it tears me up to see the struggles we've had. Contrary to what we've heard, Winder has negotiated in good faith. In fact, we've settled 39 out of 41 services. The only two that remain are roads, which is common across the state, I believe, and then water service territory and water rates. Our lack of coming to an agreement, I'm not sure is a failure on the SDS Act. And I believe in the Act. I like the intent of it. I like the no double taxation and the no duplication of services. But I'm facing both of those in our struggle. And so, you know, instead of a failure in act, maybe it is a failure in the local leadership. Of course, I don't want to believe it's me, but I soon will be out of the picture, and if that's the case, then it'll solve itself. And I'm a layman, I'm not an attorney like some of you guys, but I've thought about SDS for a lot of years now, and I think about it a lot. I wake up thinking about it. One change, and Senator Gannon and I talked about this, I think Mike would be helpful. When it comes to utilities that cost so much to develop a utility system, to permit it, to finance it, and they are specific to territories and to areas. I think once a utility territory and map is agreed on, I think that map should stand. I think it should survive an SDS negotiation. Until it's changed, I think those territories ought to be fixed. I mean, and I thought we had those in Winder. And as far as one of our issues are water rates I talked about, I think the Act covers that. I think it has real good method of resolving water rate issues. It's just the lower courts decided not to use that. They wanted to go a different way. So I think that part's good. I had one more point. I can't read. I'm about half blind up here. Oh, one place, and one dispute we had that is settled, one service area is ambulance. And I think this is a case where the Act worked. The county provides ambulance countywide, but they wouldn't provide one in the city, which we felt desperately we needed. But through a process in SDS, we negotiated and we have an ambulance in Winder. So I think the Act works to that degree. Senator told me not to do a long presentation, so I'm not, but I'll be glad to answer any questions if I can.
Are there any questions? Thank you very much.
Thank you.
Mayor
I
Maynard.
appreciate what you're trying to do up here.
Well, yeah, it's a yeoman's task. I'm going to call on another good friend, that come speak next, and a former colleague, Andy Welch, who's represented the city of Winder in that same Supreme Court case. And Andy, if you don't mind, come forward and let's hear a different point of view.
You know, Mr. Chairman, I don't know that I'm going to have a whole bunch of different points of view on this. Gentlemen, some of you know me, some of you meet me for the first time today, but I served in the General Assembly for 10 years, from 2011 through COVID. And let me tell you, this legislation, the SDS Act, which was enacted in '97, has worked really well for 3 decades. It has some problems with it that you've heard about today and you've been hearing about. And so I think that there's room to address it and improve it. But one of the things that when I get hired by a community to negotiate SDS agreements, the first thing that I tell the mayors that hire me, or it could be commissioners, because I represent 3 different counties as well, and have gone through those SDS negotiations on behalf of counties. And when I do that, I tell the leaders that the bottom line, the SDS Act is intended for leaders to be leaders of their communities. The involvement of attorneys and consultants is helpful to an extent. It is also problematic. And I'll get into some recommended changes to the Act, but sometimes more process is not helpful. I think you heard Ms. Davis go through a detailed explanation of different recommendations that you're looking at. But let me tell you, every time that I've gotten involved in these kind of disputes, whether it's local option sales tax or it's SDS or any other number of things that need to be resolved, even SPLOST, the more process you build into it, inevitably puts people into positions. They start to fall back into these positions, and then they become reluctant to change them. And so I would caution against adding more process. I think that the existing process could be streamlined. And I think you should go to a time clock. I think you need to set specific time frames, you know, whether it's 3 months, 6 months, but you need time frames and you need the sanctions to be in effect. I'll tell you an interesting story. When I started doing some of these cases, the judges would just take the sanctions off. Sanctions go in automatically under the statute, and some of the judges would just, okay, I'll sign an order that says the sanctions come off. And then what do you have? You have Fulton County, where you have no SDS agreement for decades. Well, that's not helping the taxpayers. I mean, the whole point of SDS that the General Assembly put together was to provide for a protection against taxpayers paying twice on taxes, subsidizing services they don't receive. It's a very fiscally conservative piece of legislation. It helps your local taxpayers. It doesn't help your local taxpayers when it gets into prolonged litigation or those sanctions aren't imposed that force a decision. And when those sanctions are held in abeyance, you get a drag out. And I'm not here speaking on behalf of Winder. I'm sort of wearing my old hat. What I told the chairman was that when he asked me to come, because I had no intentions of coming, but when he asked me to come, I said, well, Senator, if you don't mind, I'm just going to speak my mind, and I'm probably going to be wearing my legislator's hat, former legislator's hat, rather than representing any one group. I'm not here on behalf of ACCG or GMA or Winder. I'm really here to talk to you because you're you're struggling with legislation, and that's hard. It's hard work, lots of information. So I thought, how can I be helpful in that regard? Because that's the objective of the committee. And so my thought process went to, look, you know, I think sanctions need to be imposed. I think there needs to be a time frame in which, after a certain point in time from when it's kicked off, you know, a set of sanctions goes into effect. Now, I think you ought to do it piecemeal, not all at once. Maybe you do financial, as Chair Graham mentioned. You know, maybe you go to the pocketbook. If you go to permitting can really have a negative impact on the individual property owners that need those permits, businesses, industry that's moving in. So maybe that one kind of falls off a little bit later, and that's imposed at a later date if you don't get an agreement by X date. So let's say 6 months, no agreement. All funding that is managed by the state is just frozen. I'm not saying taken away permanently, just frozen. The tap stops. Just turn the tap off. No more money. Okay. Let's see how that works for you. That's probably going to put people back together at the table. Maybe 6 months later, that's not resolved, then you turn off the permits. I'm not saying that's what it should be. I'm just giving you just an example. And then and facing those realities of money being cut off and then permits being cut off, it gives you two sets of windows to negotiate. It readjusts and forces people to recalibrate. So I think the sanctions is the most meaningful tool. And in the cases that I've been involved in, and I've negotiated about just under 40 service delivery strategies, all of them being decided in mediation or early negotiations. Only 3, I think, maybe 4, have gone to court. Actually, only 4 have gone to court. Only 3 have resulted in a hearing. And so, in my experience, that's 10%. So it's not really that big of a problem, but when it is a problem, it's a severe problem. Putting the sanctions in place helps to force that problem to go away on its own by leaders being leaders. And in 2 of those cases, the judges figured this out. And what they did was they did exactly what I'm suggesting you do now. They put a time clock on us. They said, you know what, guys? I'll lift the sanctions while you do mediation. If you haven't solved this problem by X date, finished your mediation, and I've gotten a report back, then sanctions go back in place. And so even the judges started to figure out that their best tool in the statute was the sanctions. And I think that is the best tool you've got. So I would urge you to look at that part of it. You know, this legislation allows local control. It allows each and every chairman who's here today and mayor who's here today to discuss those issues and resolve the issues based upon what those issues are to the community. And they vary from community to community, whether it's ambulance, roads, EMS, dispatch. Gosh, the services are, you know, it's, as Ms. Davis says, there could be 50 plus more services depending on how much you break it down. So I would urge you to allow that local control to remain. Allow local leaders to be local leaders. I had a mayor that called me in. He said, "Come in here. I want to negotiate. I want you to be part of our negotiations and help us through mediation." We go into mediation. We're doing the negotiations back and forth. He says, "Andy, hold on just a second. You stay right here." And he steps out and walks over to the chairwoman, and they go into another room, and they come out and they say, "Hey, Andy, I got this idea. Why don't we trade a little bit of that lost money that we get to the county, and they'll do this and we'll do that. And what do you think about that?" I said, "Are you good with it?" And he said, "Yes, sir." "Is it legal?" I said, "I think it is." He said, "All right." They went back in. We were done in an hour after we drafted up the documents, sent it out, done. Leaders being leaders. Had somewhere in the South Georgia, one of the commissioners and the mayor stepped off, talked about it, figured out what they could resolve, went back in, sold it to their commissioners and council members, and it was done. I had another one where I asked the mediator to instruct the group that no lawyers be allowed in the negotiation room. All lawyers step back and step out, and that settled too. Look, I'm happy to be a practicing lawyer and to do the job that I'm supposed to do. But this isn't helpful to communities when they're paying lawyers the money that ought to be exchanged to get a deal done, period. That's not what this statute is intended to do. Now, I do think you need to keep an ultimate decision-making authority in the Superior Court. I think those provisions are helpful. They've been upheld as constitutional. I don't think you should change that because there may be situations where there is a real legal issue that is blocking it. And that's the case in the Winder-Barrow case, a real legal question that has to be answered. So that should still be there. It needs to be that stopgap measure. But if you put the sanctions in place and you put people on a shot clock, then you're actually going to help the leaders work that out and negotiate that out earlier and not require the courts except in those very extreme circumstances. You know, I don't come to you telling you that I've thought of these ideas recently. I'll share with you this, that in 2013, I'd only been serving for on my third session, and I actually drafted legislation to do a lot of what I'm talking about here today. So I'm not coming to you as someone who's been trying to make a living of practicing law under SDS. I actually try to put the sanctions in place, make them hard, make them financial, put triggers involved, and that was House Bill 855. So you can go back to the 13-14 session and pull up House Bill 855. Now, I don't think it was the perfect piece of legislation. I don't even think it was the best, had all the best ideas. But one thing it did do is it made those sanctions come into play and stick, and the judge could not remove them. And I think that's an important point of that legislation that would work well here. So when you go back and look, you may find that that legislation also touched up other parts of the bill that probably need to be tweaked and addressed. And you might look at that legislation as something helpful in terms of guidance. I think you will improve upon that and make better legislation than what I was trying to draft then, because even with the experience that I've had over the last decade, there are other issues that can be resolved in the act that should probably be addressed. But I would recommend that to you as someone who looked at it before and saw this same problem happening. The last point I'll make for you is that this issue of veto power and timing of the process, ACCG, I think, had made a really good point at the last meeting, and GMA along with them, both jointly, that that process needed to have a definitive time frame to resolve itself, and 10 years seemed to be a good time frame. The legislation that I proposed in 13 actually set that required that a renegotiation occur on the third year after the decennial census. Well, that's the year after lost. So you negotiate lost out. Now you know what your funding is. Now you know your money. And then you turn around and you negotiate out your SDS and services. And so that was an idea, but I think the 10-year idea is good. But if the parties want to do a shorter term, a shorter fuse on that, they need to. I think it's also a good idea that those service areas, that the agreements themselves, they remain in effect unless the parties have said this is a date that terminates or that 10-year window comes along. I think there's a lot of wisdom in what GMA and ACCG were proposing on that 10-year cycle. I don't think it needs to be tied to lost. I think it needs to be around that 10-year window because it makes some sense relative to lost. And the last thing I'll just say to you all is that it's this concept of vetoing. This is a contract. That's the nature of it. Is the result is a short, concise agreement between the parties where they agree on all aspects of services, how they're to be delivered, how they're going to be paid for, where they're going to be delivered. And in order to have a contract, you got to have all parties signing off on it. So I think it's important to look at how maybe sanctions are put into place relative to people who want to be absent from the process. They're a little small. They're a small city. They don't need to be involved with it. They're good with however it works out. Maybe they are willing to consent with another city or county to let them represent them in the negotiations. That might be a process that would work. But you can't deal with veto issues if you also don't deal with the veto issue that exists in the local option sales tax. So if you do pull these things together, you've got the House and the Senate needs to resolve the veto problem in local option sales tax, where if a county doesn't want to sign off on the agreement, or a city doesn't want to sign off on the agreement, the tax expires, and that's a serious problem for all local governments financially. And I think that adversely impacts them in their discussions on how to pay for and provide these services under the Service Delivery Act. Happy to take any questions you may have.
Any question from the committee? Andy, I really appreciate your testimony today, and I think there's a lot of things that we can talk about, and that this is where this afternoon our goal is to come up with those recommendations that can make it work. So thank you very much.
Senator, Chairman, thank you very much.
Jennifer. Oh, wow. I'm so impressed. That's the true task of a good city manager. While she's doing that, I'm going to take a 4-minute break. I do want to pick up the pace a little bit. My goal was to try to get our speakers through in the first hour. Looks like if we can get an hour and a half, we're going to take a 4-minute break. That means you got time enough to run to the bathroom and run back. But hold that thought.
I've talked to you for a long time. She can't be as young as you look.
But I was supposed to follow you, so thanks for giving a shout out to mapping and parcel-based mapping, because that was one of the things I was going to talk about.
Ladies and gentlemen, this is your announcer. Thank y'all so much for coming back to order. Next speaker on our agenda is Mark Beatty, the Director of Planning for the Northeast Regional Commission. Good to have you here, Mark.
Good to be here. Thank you, Senator. Thanks for inviting me. I'm going to invite you guys to my next public hearing so I can get as good of a turnout as y'all. All right? You guys are popular. So, thanks again for having me. Regional commissions are glad to be a part of the discussion, and we're service delivery providers ourselves and to all of our member local governments. So, again, thank you. And everybody behind me, you're welcome. I gave you something to look at today while we go through this. So I'll try to be pretty short and sweet. I know you guys have a lot, to consider, and this is a very nuanced discussion with a lot of pieces to it. So the portion that I'm going to be talking about is just a very small piece of that puzzle regarding the mapping side of service delivery agreements. So a couple people before me have already spoken to this a little bit. I will probably reiterate some of the points that they said. But yeah, I believe you guys have these slides, so we'll just kind of go through it. And I don't have a clicker, so yeah, I'll just let you know whenever to change next slides. These first couple, I'm just going to give you all some context on the three pieces that are part of my discussion. One being the regional commissions and their role in service delivery strategies and mapping and the submission to DCA. The second being the Service Delivery Act itself. And then the third being what GIS is. So I was told to come to this assuming that you guys had not used GIS or Esri products before. So if I'm a little bit pared down, please excuse me. But just to give you all some context on regional commissions, I'm sure you guys are already familiar with what we are. But if you're not, here's a map of all the regional commissions in Georgia. Georgia Association of Regional Commissions is the organization that collectively binds us together. And we are part of the state service delivery system, as it says. We help with regional planning, local planning, aging services, basically overall just workforce development. Our overall goal is to provide technical resources to our local governments. We end up working a lot with smaller local governments or more rural areas just because they don't have the staff capacity to do so. So we are a way to kind of give them collective purchasing power, so we have full-time staff that can help them. We work with local, state, and federal partners for all the work that we do. There's quite a lot that falls under that umbrella. Next slide, please. So just to give you some context, y'all are in our region, which I assume is why we were asked to come and speak with you, so we appreciate that inclusion there. Brazelton is at that northern tip of Barrow County. We have a 12-county service area at the Northeast Georgia Regional Commission, and I've got a couple of slides there. I've highlighted in green the points that are specific to the topic that we're discussing today. So the Planning and Government Services division, which is my division, is the main one that's applicable to SDS strategy, submission to DCA, and assistance to local governments. And we work with our two other area agency on aging and workforce development. Next slide, please. So just in case, let me get a raise of hands from you guys. Have any of y'all ever spent your entire day staring without blinking at a map in Esri Arc Pro? Y'all ever done that? It's easy to do. It's one of those programs that can suck up your entire day. It takes a lot of work, a lot of technical expertise. Just to give y'all a definition of what it is and why it's important, it's a spatial system, geographical information systems. It's a spatial system that creates, manages, analyzes, and maps out all data points that you're wanting to show on a map. Having that bird's eye view is very important and useful whenever you're making decisions on what types of services you want to offer, but also how to maintain and expand those systems. GIS is a very important tool. It's very ubiquitous in the planning field. You kind of can't get around using it in one way or the other. And so again, in green there, the benefits for GIS is it improves your communication It improves your efficiency in offering the services, and it works to give you a better management decision-making tool, which is extremely important in SDS negotiations. Next slide, please. So this is straight from DCA's website right here. The intent of this act, which I'm sure you guys are very familiar with, is to provide a flexible framework for local governments and authorities to agree on service delivery. There in the middle, very important for mapping, is to minimize any duplication or competition among local governments and authorities in providing those local services. So imagine if you didn't have a map showing where you're providing water and sewer services, and everyone was just relying on their interpretation on the ground level to negotiate. That would probably be pretty problematic. Mapping is very important in that part of things. And then lastly, the intent of this act is to provide a method of resolving disputes, which you guys have heard from the attorneys about. I won't get into that one though. That one's beyond me. Next slide, please. If y'all haven't ever gotten into the nitty-gritty of a SDS agreement, you've got 3 parts to it. You've got Form 1. It kind of provides an overview of all the services that are provided by this local government, and outlines any changes to those services from the previous agreement. Form 2 is a summary of the service arrangement per service that they offer. So water gets one Form 2, sewer gets another Form 2, so on and so forth. And then it is most of the time, I know Angie pointed out that DCA has kicked back some service delivery agreements for not including a map, but maps are not tied to every Form 2. So most of the time, they are tied to water and sewer, 911, or EMS delivery, but they're not included for all of them. I don't believe that is a rule, obviously. So next slide. So I wanted to give you guys something to look at so that you could see the variety of maps that you get in service delivery strategies across the state. So I've got a couple of slides here, and I'll just kind of go through really quick, not to point out that these are good maps or bad maps, because I don't want to hurt anyone's feelings. I just want to point out the differences and show how those differences can play out in having a conversation. So you see that first one there on the left, that's Morgan County. Most of these maps I'm going to show you are Northeast Georgia centric. That's a pretty decent map. It's got roads, doesn't have road names, but it's got a roads layer there, doesn't have parcels, and this is for land use planning services through the local government, but it at least shows the boundaries or the municipalities of whose responsibility it is to provide land use planning services. So very clearly, the city of Madison provides their own, Morgan County provides it for the county, unincorporated county, and 3 other cities. Those 3 other cities are kind of hard to see, but they're tucked in there. And then you've got the JDA providing services in their little corner on the west over there. So it's pretty clear, could be improved on, doesn't have road names, like I said, doesn't have parcel lines, but pretty decent map overall. It's got the components, it's got a legend, letting you know what the symbology means. That one on the right is a little bit different. Could be better. That one's got road names, unlike that one on the left, but it is very pixelated. If you're getting into how to discern where that is or what that means, you can't really get a lot of information from that map because it's not readable. The only person that's going to be able to read that is the engineer who created it and has a giant 38 by 40 or 48 by 36 hard copy print in his office. So could lead to some confusion. Why are they what? I'm getting there. I'll get there. Yeah. So that's kind of what I'm getting there is that there's no standardization for the types of maps that get created in service delivery. It's kind of up to the local government. Oh yeah, you're fine. And so that can lead to confusion. Like Angie pointed out about parcel lines, that one on the right for Jasper County, it's very clearly not based on parcel lines there with the city of Monticello's water service area. So whenever you get into a dispute potentially in the future, and you've got a parcel that's split in half, GIS has an accuracy of about 30 feet, give or take. So there's a little bit of a gray area in there. So it's really good to be parcel based whenever you're creating these. Next slide. Here's a couple more showing good and bad traits. The one on the left is Gwinnett County. Their 911 emergency call service. Doesn't have parcel lines, but you can kind of infer that 911 emergency call service is offered by Suwanee, Duluth, Norcross, Lawrenceville, and Snellville just by that hatch pattern, and that the county takes care of the rest. But again, you're having to kind of infer that from this. It's not necessarily clearly discernible because you don't have parcel lines to kind of show that. So it's good for local government negotiations. It's also good for the public. If anyone from the public were referred to these maps, maybe it would be kind of difficult for them to read it. It also doesn't show one of the better ways that parcel lines would have worked in here is for the city of Auburn and Rest Haven there, where they cross county boundaries, and Brazelton too, where they cross county boundaries. If someone from the public were wanting to see which 911 emergency call service applies to their parcel, it'd be kind of difficult to tell from this map. The one on the right is a little bit better. It doesn't have parcel lines, but you can see that the boundaries are based on parcels. It has road names. It has call-outs telling you where the city limits are and what that green line is, a sewer service area map. So that one's pretty clear. I feel like with some time taking a look at it, you could really discern, very clearly what that boundary is, and can lead to, quicker negotiations because you know very clearly what you're looking at. Next slide. Here's one that's a little bit more difficult. This is essentially a screenshot that someone took for where they had a good idea. They pulled in their layers into an online map system on Google Earth so that you could zoom in and zoom out and see where these electric transmission territories are. So on an online platform, that would really work. Looking at it right here, it's pretty difficult. So could be better. Next slide. And this, I'm going to give a shout out to Joel Logan. He's the GIS manager for Jackson County. He is very good at his job, and this is a very good map. Now, so I wanted to give him some praise for it. A very clear map. Again, doesn't have parcel lines though, but it very clearly states with that call out there and with that green symbology where the city limits for Brazelton is and where there's a county maintained roadway within the city of Brazelton. So, unarguable map. Jackson County provided 6 maps just with their road maintenance showing those exact things where there were these nuanced roads that the county was maintaining within the local government. So very clear, good messaging through their agreement. Next slide. So the implications of a bad map, and these are kind of worst case scenarios here, unclear service boundaries. If you don't have a clear map showing where service boundary is, then that could lead to confusion from the providers and to the public at those boundary parcels. And who knows, maybe it could lead to an argument or a dispute in the service delivery agreement. There are no way to track any metrics to see if that's ever been the case, but it's a possibility. And then complications during staff turnover. I've had situations where I've worked with local governments where maybe one person truly knows the extent of the service delivery of a service that they're providing. And that, if you don't have a map that's showing where that is, then that could lead to complications during staff turnover and having a transferable knowledge base. And then it could lead to duplication of services. If you don't have a clear boundary that's clearly shown and agreed upon, then hey, you could have a duplication of services, and that's going against the intent of the SDS Act. So, next slide. All right, I told you guys I'd be quick. So, final remarks here. I just want to make sure you guys are clear on the role of what a regional commission takes on in SDS updates. We provide, per our DCA contract, provide GIS assistance upon requests. Emphasis on upon request for SDS mapping. It's kind of up to the discretion of each regional commission on how involved they get in that process and if they are a piece of that puzzle, and whether or not they charge a fee for that service. And then also we assist with, per our contract requirements, we assist with the submission of the SDS agreements to DCA and make sure that state tracking on SharePoint is maintained with them. So if I had any recommendations for you leaving today, it would be to, if you suggest any changes, whether they be legislative changes or procedural changes, make sure you're discussing that with DCA. They're the ones that are charged with the responsibility of overseeing this act. So it'd be important to have them at the table. There's a potential for statewide mapping standards, like you had indicated in your question. And there would be a potential to expand the use of online maps. That would give the public and the local governments the ability to zoom in and out on the extent and really get a granular view of the extent of what their services are and really just help with the discussion. It's essentially just supposed to be a tool. Those two things could potentially make the tool better. So I'll give a shout out to Susan Miller. She's the state geospatial information officer with DCA. I think she'd be a great person to have in the conversation. All right, I'll take on any questions if anybody has any.
Are there any questions from the committee? Mark, I want to thank you for your presentation. I also want to give a shout out to Burke Walker. Burke is the Executive Director for the Northeast Regional Commission, and glad to have you here. Burke, so great job on the presentation. Next, I'm going to call on Mark Smith. Where's Mark? It's kind of interesting, the Service Delivery Act kind of mutes the private water systems or private utilities in the state. But at the same token, I had dinner last night, said the mayor, with Mr. Smith here in Brazelton, and I didn't realize when I met him a few years back the extent of his service and what he does in providing water to 33,000 homes. 31,000 homes here in Georgia. So, Mr. Smith, the floor is yours.
Thank you very much. I appreciate the opportunity for Water Utility Management to submit testimony to the joint committee here today. And I've given you all a handout. I believe you have information on our company and a copy of my testimony. So Water Utility Management has been designing, permitting, constructing, operating, and acquiring private water and wastewater systems since 1970. We presently operate over 200 systems with over 400 wells, serving 31,000 households in 17 different counties in southeast and south central Georgia. We're the largest private water company in the state of Georgia. We respond 24 hours, 7 days a week in our service areas. We have a robust inventory of spare parts and pumps and motors in stock, and we've proven to be very capable and reliable. Because of our performance and track record, EPD has granted us delegated authority. We're the only private water company in the state of Georgia that's attained that level of certification. So under delegated authority, it means we're regulated by the EPD in the same manner as a medium to large municipality. This delegated authority requires us to have approved plans and specifications for all expansions and construction on file with the EPD, and allows us to expand our systems with pre-approval from EPD. Our engineer of record then submits a report at the end of the year detailing our expansions under the same regulations as a medium-sized municipality. We hope that the committee members will recognize that there are significant water and wastewater services delivered to hardworking Georgians by private companies throughout the state. In Camden County, our company has a franchise agreement to provide water and wastewater services for a portion of the county. This is at I-26 and I-95. It's designed to serve about 2,000 homes. This relieves the county of the burden of infrastructure investment and operational responsibilities. We're discussing this same arrangement with many other counties. It should be noted that the Service Delivery Act does not recognize the vital roles that private companies play in service delivery. Southeast and South Georgia is blessed to have the Floridian Aquifer as its primary source of water. And there's a map attached to the testimony. This is one result of this abundant resource is that prior to 1997, most counties did not have to develop costly countywide service delivery systems in this region of the state and provide water from a central plant. Because the technology is relatively simple and inexpensive to drill a well, growth occurred without countywide water systems. During the first 150 years of industrialization, South Georgia water seemed to be limitless. However, in the 1980s, saltwater intrusion became a problem in the area of Hilton Head, and South Carolina threatened to sue Georgia for overpumping the aquifer. The first Floridian Aquifer moratorium was established in 1997 for Chatham, Bryan, Liberty, and the southern half of Effingham County. Over the time, the operators in Chatham County, in collaboration with the EPD and some of the major industries, and every permit holder has undergone a 19% reduction in our permitted capacity, and we've reduced the pumping in Chatham County from 93 million gallons a day to 52 million gallons a day in 2022. That's a 57% reduction in pumping of the groundwater. Effingham County's permitted capacity has shrunk at least 30% during that same period. During this time, we continued to build systems in our area permitted by EPD with our permitted water sources. Over the years, we've connected systems together and we're required to convert from drinking water permits to groundwater permits. Today, we continue to consolidate our operations and our permits. A drinking water permit covers systems pumping under 100,000 gallons a day and sets a specific number of taps that can be allowed by the permit. When water exceeds 100,000 gallons a day, the system is required to have a groundwater permit. With permission from EPD, we have moved water capacity from county to county, from permit to permit, to construct systems. We've also accepted groundwater permitted capacity from the city of Port Wentworth in exchange for the sale of a water and wastewater system. The water capacity was then allocated to new neighborhoods, housing developments, mostly in Effingham County. As a result of the permit consolidations, we now have 1.2 million gallons of groundwater capacity in the restricted red and yellow zones, which are Chatham, Bryan, Effingham, and Liberty counties. This is enough for about 4,600 homes. Despite the critical need for water capacity to serve much-needed housing, we face significant problems being able to utilize these permits. The existing service delivery strategy agreements between city and county governments do not provide a window of opportunity for private water providers. We are asking for a level playing field to deploy this permitted capacity. We request the right to expand our existing systems, and I think this could be really ameliorated in some extent by if you would just put the private systems on the map, and so that it becomes part of the service delivery, which is in effect what is happening. We are providing the service, but we're just not included in the service delivery areas. That would go a long way toward defining this issue. In one situation, I control land next to an existing subdivision and would like to add 65 lots to the subdivision and have it served by our water system, but I'm not sure it's going to be allowed under the service delivery strategy. Please note our area is experiencing a severe housing crunch. We have 20,000 manufacturing jobs headed our way in the next 18 months, and we have got to do something for housing. Our company can deliver water service quickly by drilling a permitted well as opposed to waiting for central infrastructure to arrive. We are currently under a zoning moratorium in northern Bryan County while the county determines their water and sewer infrastructure needs through a land use plan that's still under development. The cost and timing to develop this system is unknown and will rely on water coming from new wells developed in Bullock County. Presently, Chatham, Effingham, Bryan, and Liberty counties do not have any significant available Floridian aquifer groundwater capacity. Chatham County sold their water systems to us in 2016, and Bryan is drilling multiple wells in Bullock for service to the Hyundai plant. Effingham purchases water from the City of Savannah's I&D plant, and Liberty County is trying to develop a system using the Miocene aquifer, which is considered by some to be not as robust as the Floridian. All these solutions involve running miles of pipe, building pumping stations at significant expense for the citizens of these jurisdictions. Cities and counties are asking for significant loans from GFA, grants from the state, or ARPA money to underwrite these expansions. These expensive systems are then proposed to are required to charge large cost recovery or tap fees and consumption fees for the cost recovery. And there's also a lot of debt involved. Our company can deliver services more cost effectively, more quickly than a central public system. We pass these savings on to the developers and the new homeowners. We request that we be allowed to serve areas in the coastal zone if the respective county cannot provide the service within 1 year. Specifically, we're asking that the service delivery statute be amended to provide for statutory ability to be able to expand services in underserved areas of a county by a private water system or a municipal provider. Some municipalities may be interested in this operational flexibility, and with this new tool and opportunity, we're prepared to begin to deploy the flexible permit capacity we hold to meet the demand for affordable housing we're seeing from rapid industrial growth. Well, thank you for your time, and I'm happy to entertain questions.
Are there any questions from the committee? Speak.
One or two. How many other private water systems are in similar situations around the state? Are you aware of any?
I mean, around the state, there are not that many around the state. We're kind of a unicorn down in the coastal region with these water rights in the restricted counties. I don't know of anybody else that has the significant rights that's in the business.
At the end of the day, in that region, we're going to need every gallon of water we can find. And at the end of the day, none of the counties have the permitted ability today to provide for the growth that is imminent.
Right.
My big concern is we've got one county having to go to another county to drill wells to pump water back. Have you seen that in any other area?
Yes, it's happening in the town of Riceboro in Liberty County has drilled wells over in McIntosh County, and they're pumping water back from McIntosh County into Liberty County. The town of Hinesville has entered into an agreement with Long County to do the same thing.
Doesn't that then argue for some kind of a joint multi-county approach toward water and sewer management?
I would think so, and I think the other, these EPD's taking a hard look at these wells because ultimately, I think I don't want to speak for EPD, but they're looking at granting permits for the Hyundai plant that would have a sunset on it, and then eventually the water would have to come from an expanded I&D plant of the city of Savannah and run treated Savannah River water up to serve the Hyundai plant. So it could be that these permits are a temporary, well, I say temporary, maybe as much as 20 years, but a stopgap method on the way to a surface water plant. So, I mean, we've done a lot of work. We've all suffered a lot of permit reductions, and producing, the Savannah I&D plant produces 55 million gallons a day. It's near capacity, but we have dramatically affected the saltwater intrusion issue in South Carolina, much to the benefit. They used to tell us 5 years ago that saltwater would be in Georgia in 125 years, and now they're saying, well, it's probably going to be over 200 years now. So that's the result of all the conservation efforts.
Going in the right direction. Chairman Docker, you have a question?
Yes, Mr. Chairman, if you don't mind. So I think you summed it up when you said you're a unicorn. When you look at this, as Senator Burns suggested, this is something that I've never even really thought about, that you're providing that service to so many different customers. So should there be a threshold, if you're doing this as a private company, should there be a threshold that's included in SDS? If you service X number, then you're required to provide that map, that service map to the local government so that it could be used for planning. And if so, then is there an appropriate size for a utility company? If you're a certain size, should you provide that? And I think you could probably go beyond water with other services as well. And then I've got one more point that I think we need to ponder, and I can only pull on my experiences. I know we had a private sewer facility that served a portion of our county. And if that private company were to fail, then that responsibility to provide that sewer service fell back on our authority to do so. So with you serving so many homes, and I'm sure your company is prosperous and will continue to do so, but is there any kind of agreement in place should you fail to meet your requirements to provide this service that would fall back on a local government entity?
Sure.
Those are just a couple thoughts.
That's a great question. Back in the 60s, I believe it was, or early 70s, the state came out with a plan. They required a trust indenture for every water and wastewater system, and they were in place for about 45 years, and they never had to call on the trustee to do that. So it was a protection, but it was never called upon. I don't know the exact status of the trust. I don't think trust indentures are required for water or sewer anymore, but in any event, that's what was in place, but now it was never utilized, so they finally removed the restriction because it was actually very cumbersome on the deeds and titles to all the assets, is why they removed the requirement.
Mr. Smith, since I believe in local control right here in front of you, one of the things that, for me, I know we don't spell out private utilities in the service delivery, but if you had each of the local governments that you serve in to basically put you in their plan from the jurisdiction that you're in, would that not serve the same effect of what you're trying to do? So that, they're saying, hey, we've relegated this area to XYZ water company or something along those lines?
That's what I'm advocating. I mean, there's certain areas throughout our entire service area that I just know there's not going to be any municipal, some of these are islands in Chatham County. There's not going to be any municipal service, and the county's already exited the water and wastewater delivery business, so they might as well designate that particular Burnside Island as being served by a private company. I mean, we would just like to be on the map.
Okay, thank you. And, Chairman Corbett.
Designating that area, is there any restriction for the county or city contracting with you to provide that service in the area?
No, there's no restriction, no, just like,
So I still think it needs to go back to the local government, like in our service delivery, we have where after so many days, they have a letter, and then after a year or two, they can provide, they can go to the private company.
Right.
Or you can negotiate with that city or that county who has that service area to provide that service. And to me, that seems to satisfy what you need, is that you're not restricted to contracting with Effingham or Bullock or something.
no, in fact, we welcome those contracts.
So other than mapping where you are, I don't know that we need to. And other than, that's better, that's much better. And so rather than providing a requirement in service delivery that mentions private systems, it just seems like including you in the mapping would be the main portion that we need to do as a committee, so that those good governments know who the private providers are, so they can go to you if they have an opportunity for growth and say, hey, it's going to cost us $12 million. You can drill a well right there for $1.5 million.
Right.
I
think we need to leave it, in my opinion, on the local governments.
We got you. Mr. Smith, I want to thank you for your comments and your time today. I enjoyed learning a little bit more about your business.
Thank you so much, and thank you for dinner last night. Really appreciate that.
Of course. Look, if I look down my agenda, and I come over here to, this is the dog and pony show from our friends at ACCG and GMA, and I'm going to call on both of them at the same time, because Clint Mueller with ACCG and Jim Thornton with GMA, and I've tried to remind them that we're supposed to be done with the presentations at 2, and they're 44 minutes behind. So how'd y'all start off so late?
Thank you, Chairman Ginn. Thank you, Chairman LaHood. We hear you loud and clear. We will be extremely brief because I know you want to get into your discussion. Really, the only thing I think Jim and I wanted to do is really just give you a quick update on the status of our joint task force that's been working on this issue, as well as local option sales tax. And then as far as what's in your materials before you, we're not going to comment on any of those. We'll be available, though, as you all discuss this. If you have any questions for us, we'd be happy to answer any questions. So on an update, if you'll recall at the Valdosta meeting, we talked about our task forces in their work. And at the time, they were talking about trying to align SDS, comp planning, and loss together. That was a part of the presentation that I gave. Part of the presentation that Jim gave was talking about the dispute resolution process, and we talked about having a panel of people that would come in from the outside, hear these disputes, and they would not make a binding arbitration decision, but they would make a non-binding arbitration decision, but there would be penalties attached to that. Our task force has gotten back together again. They now want to go in the direction of figuring out if there's a formula that can be agreed to on lost. So in other words, don't have a dispute resolution process at all for lost if we can come up with a formula. And so that's really changed things. they're now looking at a whole different type of dispute resolution process for SDS. Something that would be definitely non-binding arbitration or mediation, not a whole panel that would be hearing it. They're still trying to work through the details of, what's better, non-binding arbitration or mediation, or an option to do either one, and who gets to decide that. So those are all things they're still discussing. They also, since we last talked, I think they've made the decision that they don't want to touch anything that's under litigation. You've already heard that today. They want to let the Georgia Supreme Court come out with their decision on that and then maybe address that later. So our task force, where they are, they want to have another meeting. They said probably the 1st of January. We may try to speed that up and do something before the end of this calendar year, but it's difficult, obviously, during the holidays. So right now, they don't have any meetings planned between now and the end of the year. They want to continue to work and try to reach a consensus, and then if they do reach a consensus, their recommendations would go to our respective policy councils. GMA has a policy council, we have a policy council. They would look at those recommendations and decide whether they agree with them or not. And then we'd be ready to make formal recommendations. Again, I know that doesn't fit your timeline. I know that you all have a quicker deadline that you're trying to achieve. We're still going to go through our process regardless and see where that comes out. But again, happy to provide you all with any input today that we can. And Jim?
Sure. Thank you, Mr. Chairman. I'll be brief also. I agree with the report that Clint's provided on behalf of GMA and ACCG, our joint task force. Y'all have heard, this is your third meeting. At your first meeting, you heard at length from Clint and me, as well as Larry Ramsey and Rushi Patel from our organization's legal departments. And then Clint and I were in your meeting in Valdosta and shared some ideas that our task force had kicked around. And at that point, they were just ideas. I think what you need to recognize is, and you do through this testimony, is that the complexity of these issues are what our task force has also been grappling with, because these are very complicated issues. With 159 counties, 537 cities, everyone has figured out a little bit different solution in their location that works for them, and the flexible framework of SDS is working like it's intended. And then we have the flashpoints where the agreement is not reached, and that's what gets a lot of attention. But in the large majority of these cases, agreement is reached by the local governing officials. But because of the complexity and because of the variety of solutions that people have reached across the state, our task force members have heard that. And they have heard that this solution or that solution might not work in every community, might not work in their community. And so as they have processed that information, they've gone through a very deliberative process, much like what you have done. And I think where, as Clint indicated, I think where we're probably going with this is getting the task force back together, continue having conversation about procedural improvements, not trying to create any kind of substantive rulings, if you will, or changes, or imposing any kind of substantive solutions, but seeing are there ways to improve the process. As mentioned, if we separate loss, right now, LOST and SDS are not necessarily aligned. We were talking about aligning them. That creates its own set of complications. So now there's some talk about not necessarily aligning them, going with more of a formula-based solution for LOST with some measurable criteria, making SDS stand on its own. And so as we move in that direction, we will continue to keep all of you informed and updated on that progress. But right now, we haven't come to a place where even we still have internal disagreements among county officials, disagreements among city officials, because there are different solutions that would work in different contexts, Georgia being a very large and diverse state. And so we'll continue to work through that and report. We certainly appreciate the recommendations that the chairman have supplied, the 11 recommendations. Feel like there's a lot of merit there. That's something that we will continue to work on with our task force. Appreciate Chairman Corbett as well with the recommendations that you supplied, and certainly we'll take those back. And all of your discussion today is something that we will take back to our task force as we continue to see, in parallel with the work you're doing, are there recommendations that our associations can support. And we'll be here for questions during the Q&A.
So is it your goal, the two policy committees, to have your recommendations by, did you say January? Just want to clarify what your goal is
So recognizing that the legislative session has its own calendar, we know that if there was going to be a chance of legislation moving forward, we would need to have that in legislative form in January, probably by the end of January. So certainly our task force is looking at getting back together maybe once more before the end of the year. We talked about getting together again during the budget week, the budget recess. But from our perspective in ACCG, I'll let Clint comment on his policy process, but our staff can't represent GMA, our task force members, and we have three great officials, Mayor Reed, Mayor Paul, and Manager Phillips, who are serving on behalf of GNA, but they are just serving as a subcommittee, if you will, of our policy council. Once we have some recommendations from them, we'll take them back to our full 45-member legislative policy council and allow them to vet it, hopefully coming out with a formal recommendation. They do have the ability to represent a policy direction on behalf of GMA, and I think ACCG has a similar process.
Yeah, our process is very similar. I think the position we're in is if we can get some consensus, we hope to have that by the beginning of January, and that will help inform whatever legislation goes through the session. If we do not arrive at consensus and one of the legislators drops a bill, then we'll just be faced with responding to that. Our policy council will still have to be providing input, because if any bill gets dropped, we're going to provide input on it. And again, the things we're okay with, the things we don't like, if we don't like something, why. But it sure would be much easier, I know, for the legislature if we can reach some consensus and come with a unified position, which is what we want to do.
And that is the stated goal of our policy councils, is to work on trying to find consensus.
Thank you all for your presentation. Mr. Co-Chairman LaHood said one of the great things about being on this committee is we know that the government always has the answer. So for me, I want you to look down our list, and I saved the guy with all the answers. He's kind of like the Shell answer man. Deputy Commissioner Rusty Haygood with the Department of Community Affairs. I don't want to put you on the spot or anything, Rusty, but I know you got all the answers, so come up and tell us what they are, because we're dying to hear.
Thank you for that vote of confidence, Mr. Chairman. I really appreciate it. Co-chairs and members of this committee, thank you for the opportunity to be here before you today. I promise to be very brief. I know time is of the essence. A couple of things that I just want to do to respond to the questions that have been asked of us. And as well as following the presentations that we've heard today, thank you for having them in front of us. They said a lot of things that we could have, but I'm grateful for the opportunity to be here before you. Prior to coming to the Department of Community Affairs a couple of lives ago, I was at a regional commission in the middle part of the state. And I had the opportunity to work with cities and counties as they were entering their service delivery strategy negotiation processes. And I was able to witness the extremes. One where we walked into the room and one party brings the local newspaper, one brings one of the region's TV stations to the discussions, and we knew from the word go that one was going downhill. Contrast that with, and I'll call the name, at the time it was Hawkinsville and Pulaski County. We sat down at AB's Barbecue, and an hour and 15 minutes later, we had lunch and settled the update of their service delivery strategy. I don't know if barbecue is part of your solution here, Mr. Chairman, but it might be worth a shot as we get started. A couple of things. We've heard today that this is a quarter of a century old. One of the things that hasn't really changed in 25 years is the forms that we use for the process. That is virtually the same as what we had from the word go. We just follow statute. There was no promulgation of rules called for in this act, so we've got the statute that's there before us that we're using as the foundation. And one of the things, Representative Prince, you brought up the question about maps, and Mark did a great job talking through that. The way the verbiage is in the statute, if I can find it, it says a description of the geographic area. That's what was put down as this act was created. But what we have done is we have seen the evolution from 25 years ago, literally a representation of the county with a Sharpie. That's a visual representation. I would consider it to be a map. Today, we've gotten a little more sophisticated. I think all of those hand-drawn maps are just about, if not all the way out of the queue as what the existing maps may be. But as Mark described, a digital representation is definitely advantageous. That's something that we would definitely encourage through the process. It is a challenging process, and we understand that when you have to draw a line in the sand, that's automatically going to create conflict between parties as you start a process that says, this is mine, this is yours. That's both geography that gets brought into the context of money, and it is a challenge that has to be worked through and overcome. And I think the word that's been thrown around is leadership. And I think that's one of those things that's critically important in this process as we consider local leadership is definitely imperative to making sure that these processes flow as smoothly as possible. At DCA, I'll say a couple of things that we embrace. Number one, we embrace reducing conflict between cities and counties at any opportunity. That's something that we desperately want at all costs. We also don't actively advocate for penalizing local governments, but whenever you can't come to a requirement, there have to be consequences to that. And while that's not always pleasant to hear, I think it definitely means that you are going to continue working toward that solution where the absence of any ramifications means it gets put on the back burner. One of the things that I will also say we are supportive of is when there's a situation where you end up with a consolidated government where there's only one entity within the jurisdiction, let's not make them go through unnecessary paperwork to submit to the state something that says, hey, this is our service delivery strategy. There's no conflict between this one party. I think that's just simplification of everything associated with this. We're also supportive of what we generally consider a 10-year window on this. I would caution that as we look at the language that's currently in statute, there are certain triggers that necessitate that you bring this up again for revision. Some type of interim update to this, such as the creation of new cities, the dissolution of cities, things of that nature. I'll try to give a made-up practical example of this, if I may, but in a scenario where if we were rigid on a 10-year without the opportunity to update in the middle, a city gets created in year 3 of this 10-year window. If you look into the service delivery statute, it basically says that when you do not have a local government represented in your service delivery strategy, an approved service delivery strategy, you limit state grants, permits, loans, et cetera. We don't want to get into that scenario where unintended consequences, that language is in the act, and then we put a rigid 10 years. Let the local government decide when it's time to update it. But what we have noticed is that as new cities have been created in the last 10 or 15 years, we've seen an accelerated number of new cities, and that's great. We're all for residents self-governing themselves. There hasn't been a timeline that's put in place for that to be considered, for a new city to be put into the Service Delivery Act. We would encourage some type of guardrails there, whatever that may be, just so that we as an agency that's administering this knows, that communities know what the expectations should be there. And yes, sir.
Commissioners, one other thing that, let's go back to your fictitious new city that got created in year 3 of the 10-year plan. Under current law, would you kind of refresh all of our committee members what happens today with that new city that, you know, if we go over here and somehow between Braselton and Houston, which are adjacent to each other, said we managed to squeeze in another city. Said what's going to happen? It's in Jackson County, and I look at it and I'm like, okay, under current law, what would happen? And then what do you think really, is it okay what we're doing?
Well, let me quote directly, if I may. No state-administered financial assistance or grant, loan, or permit shall be issued to any local government or authority which is not included in a department-verified strategy. I think it's pretty clear there that hands are tied as far as that goes. Now, if the legislature changes that language, of course, that changes the fictitious example here. But I think in that scenario, there has to be a mechanism whereby this new city that we have squeezed in, that small little sliver, has the opportunity to be included in a service delivery strategy.
And I guess what makes the most logical sense in your mind for doing that? Do you take, okay, that's taking a portion out of what was, if it was incorporated from the two cities, then you take a portion out of those, or if it was an unincorporated Jackson County, then would you say, okay, we're going to take the money that would have gone to unincorporated Jackson County?
Senator, you're not going to get me to take a position on de-annexing cities to create new ones right here. But
I'm just saying that's why I was squeezing it in between two cities, because what's good for the goose is good for the gander, and I'm trying to play devil's advocate here.
I'll let the local governments decide what happens in that scenario. To me, it's that simple.
So your point, the city incorporates with that before, because they want to get a water grant or loan. So they incorporate, so they have water and sewer. But then they can't get the grant or loan because of non-service delivery. It would need something that would be very quickly where the county could come together, assuming there's no de-annexation of a city, and they would deem that city limits that's been incorporated by the state of Georgia now to be a service delivery for public utilities, for example. It could be a real quick text amendment, which we wouldn't have to go through the whole service delivery starting over again, but it'd be where you just sign off and get it in so they can get their water and sewer and get their GFA loan, their grants or whatever. Correct?
It seems a little more complicated than that. However,
Yeah, I'm simplifying, I know, but I think
I
that's the real
understand.
issue is
I understand.
see, I've seen these small cities try to incorporate to get some funding to get some water and sewer to an area.
Sure.
They couldn't get it without being on service delivery.
That would be my interpretation of the
Mine
statute
too,
as
yeah.
written.
Excuse me, I've heard you talking, but I wasn't sure. But did you come to something more like, hey, if we're going to make a new city, before it's approved, they have to have these types of things in space, in order before we even look at approving a city versus approving a city and then having to go back and do that type of thing? I'm just trying to figure out what's, most expedient, because, I mean, when they want that city, they're going to need to have certain requirements, and I think that service delivery strategy should be a part of that.
We're going to hold this discussion till we get done. We're going to go ahead and move forward and get Commissioner Haygood finished, and then we'll have that.
May I just close with one last thing? One of the terms, phrases that gets used quite a bit, but is separate from the service delivery strategy discussions is qualified local government status. Within the SDS, there are SDS penalties and sanctions associated with it. They are distinct, although some of them overlap with the qualified local government status. In the 11-point document that came out, we did use the term qualified local government. I would recommend that we just use the service delivery strategy sanctions that are associated with that, unless the legislature changes the penalties associated with it.
Could you help us understand, explain to those that need clarification, what is DCA authorized to do now for city and county who are unable to reach agreement as far as sanctions or lifting the QL?
As far as process, I would like to hand this to John West, who is our division director over our community development division where this is housed, and let him handle that if that's okay.
Representative Chairman, making sure I understand your question. You're asking essentially what happens when local governments are unable to reach an agreement on an SDS within the prescribed time frame?
Right, and what is the range of actions DCA could take?
So our not having any rulemaking authority or anything that's been provided to DCA under the statute as it currently exists, our hands are pretty well tied. When local governments are unable to reach an agreement, we are directed by statute to impose the penalties, the sanctions for noncompliance with statute, which essentially prohibit any state agency from providing any state-administered financial assistance or permits to the local governments that are located wholly or partially within the territory of that county. The only opportunity for flexibility exists within the context of a court-issued abeyance, which have been implemented in various manners by different judges across the state at different times. But that is really the only other mechanism. All of the dispute resolution processes that exist in statute, whether they are before noncompliance occurs or whether after noncompliance occurs, it all happens independent of DCA. The only thing that we can do is bring in the stick. We don't have any carrot. It's all stick on that end. You know, you lose access to state-administered financial assistance and permits.
So if I understand right, under current law, the judge could pretty much undo that stick, take that stick out of your hand.
In virtual perpetuity, yes, sir.
Mr. Chairman, right now, as you are dealing with some communities that do not have current service delivery strategy agreements, how many of those are under any form of a sanction, and how many of those are in abeyance?
I believe the current list of communities that are actively is 0. I'm going to look back over my shoulder at the actual program manager to make sure I'm correct. She says I'm correct. In terms of those that actively have abeyances, it's a handful. I'd say 5 or less.
One more follow-up. Of those that are currently in abeyance, what's the longest abeyance that's out there? You can estimate.
I think we're at about 14 years.
14 years, thank you.
Thanks, sir.
Did I get that on? Okay, I had a question as well. We've seen some commentary about DCA panels. Have y'all thought that through, been part of those discussions on creating DCA panels, sort of what it would take to retain those experts to be on that panel and rates and things of that nature?
We have had conversation with ACCG and GMA specifically about that. As has been stated previously, there's a comparison to annexation arbitration panels. Complete candor, they have not worked perfectly. I won't stand here and say that they have. However, we're not going to take a policy position about what is the right way for these disputes to be handled. If we are the entity that's charged with doing something, whether it's associated with this or anything else, we will do as we're legislatively instructed.
Thank you very much for your presentation, Rusty. And look, this concludes the presentations we have to do today. The next thing on our agenda is for our committee to have discussion about where we want to go as far as where we'll try to put together a report. If it's not required that we do a report, one of the things that I want everybody in the room to recognize that we have been approved for an extension on our report deadline to December 15th. So the clock's ticking, but we did get a little bit of extra time because I know we'll have a lot of ideas that we'll carry forward today and would like to call on some of our staff to help us with the writing up of the report. Hopefully we can get one. So we're going to take a little recess, and I'm going to ask if I can get a little bit of help to kind of get our tables in more of a, where we can see everybody a little bit better. Anybody that wants to stick around for that discussion, you're welcome to. I would ask for some of our staff to stay with us. We may be here till the midnight oil burns, but we'll try to work forward.